course, is accepted. So one offer, the other one accept. Again, the two parties, or if there is a wali, and inshallah we'll talk about wilaya in a minute. طيب. But again, there are some additional conditions that the fuqaha, the scholars, add to make sure that a serious matter like a marital contract is really definitive and clear. One is what they call tamyiz al-muta'aqidain, that both parties to the contract should be in the age of majority, so that they are capable of understanding and responding to the offer by acceptance. For example, even though this doesn't happen very frequently, they say if the person, for example, who is getting married, or one party is not in their full mental capability, even though they might be in the age of majority, then of course that should be really verified. One cannot really hold it, even if they don't fully understand what is going on. The second condition is that this will be done in terms of offer and acceptance in the same setting, no matter how long it takes. In other words, you cannot, for example, meet today, let's say today is Friday, okay, and begin the marital proceeding, wedding proceeding, and somebody offer, and the other one does not respond in the same setting, and then you come next day and say, I accept. Now, I'm giving some extreme example just to make the point, but this is what they call ittihad al-majlis, that in the same setting, even if you're sitting for an hour, for two, but everybody is there, then that is a requirement as well for the validity of the offer and acceptance. Thirdly, that both parties understand clearly when they say accept, for example, that they're talking about marital contract, not any other contract, so there will be no mix-up. I know, you might say it's a matter of course, but just the jurists want to make sure that no disputes happen, that when I say I accept, what did you really mean? Does it have to be in Arabic language? No. It can be in Arabic if both parties understand Arabic, no problem. It could be in any other language understood by both parties to the marital contract, as well as the relatives and audience also. I prefer it would be made in the language that most people who are sitting there can understand it. And oftentimes, when I officiate weddings, I may even use both languages, Arabic and English, because oftentimes I've seen that in Canada, United States, and some other European countries, that you find the two principal languages, at least common among most Muslims, is the Arabic and English. So sometimes I might say one part in Arabic, especially if I'm quoting from the Quran or Hadith, but I prefer also to make it in English so that everybody understands what is going on. In fact, the jurists have been so comprehensive to the point that they say even if a person can't speak, for example, that some people might have speech challenge or problem, in a case like that, perhaps even the sign, for example, like shaking the head or accept or something of that nature, even a sign language when a person can speak is valid also as legitimate offer and legitimate acceptance as well. A fourth condition, that it cannot be conditional or qualified. For example, The father say, okay, I marry to you my daughter, so and so, and the other party says, yeah, I accept if I find a job. That is not valid. It could be no condition. It has to be يعني definitive in the same setting. Likewise, a fifth condition, that it is not postponed, that you say, I accept to marry, but tomorrow I'll marry her, or accept to marry her tomorrow. No, it has to be in the present tense. Some jurists actually say it is better to use even the past tense. Zawajtuka, I gave you in marriage, or accepted, so that there will be no doubt that there is no qualification, that it is tangiz, it is reality, it's accepted with clarity. Okay. These two then are we can call prerequisites, that there is no contract even without free offer and acceptance, and as indicated in previous sessions, it has to be the free will of both parties who want to get married, not just one side offering the other without the approval of the person on whose behalf they might be part of the marital contract. Now we come to another condition that most jurists, more particularly in the Shafi'i and Hanafi school of jurisprudence, they consider as a condition, in addition to offer and acceptance, that there will be two witnesses, two credible witnesses to that procedure. In fact, there are some jurists even who said that it is rukn, not only a condition, it is a prerequisite for marriage to have two witnesses. But that is not necessarily correct interpretation, because, for example, in the Maliki school of jurisprudence, they say that it is good to have witnesses, but they say it is not in itself mandatory. And their argument is that, in a way, everybody is witness. Say, when you make or officiate a wedding and everybody knows about that, it is announced, and following the sunnah of the Prophet ﷺ, he recommended that people do the wedding in the masjid, and he also encouraged people after wedding to have daf, some kind of a drum that they use. And the idea in here is not just entertainment, but also almost like announced to everybody that these two people now are legitimately married. And by the way, it's also practically nicer and good for their reputation, so that if people see them walking together hand in hand or something, and they don't know that they are married, it is sometimes in some Muslim cultures something that might raise issues in the mind of some people. One of the ways also of announcing, which is sunnah, that the Prophet ﷺ recommended, is to invite people for food, either after the wedding or the night when, for example, she moves to the husband's household. Sometimes some people, it could be done the following morning, whichever is convenient, is to have like some meal. There is no minimum or maximum, but the approach of Islam to all issues, whether it's wedding or others, is moderation, or wasatiyya, just balance, to avoid excesses and extremes when people feel obliged under social pressure to spend thousands and thousands of dollars on the walima, in very expensive hotels. I'm not saying it's haram or anything, but sometimes they overspend, and sometimes the problem arises the day after. All this fancy meal and celebration, very costly, very excessive, and the marital life begins the day after with worry an argument as to how to cope with the debt, sometimes debt incurred in this walima or that party. Nor to be miserly when Allah has given you already the fast. So again, without excesses, moderate, reasonable, balanced approach towards the walima. But in any case, whatever opinion is taken about the absolute necessity of witnesses, or that it is a condition that could be fulfilled, what is forbidden clearly, and I'm not aware of any jurist who differed with this, that Islam does not agree with secret marriage where you have only two people, like a man and a woman, secretly, or just having one or two relatives, they go and marry in secret. It's strictly forbidden. Now, we come to another issue, aside from offer, acceptance, and the issue of witnesses that we just discussed. This is known as wilaya in marriage, or guardianship. Guardianship. Again, that is only an issue with respect to the female being married. Let me first make a distinction between two types of females. One is known in Arabic as thayyib. That's a Quranic term also. Thayyib, that means a woman, for example, who married before. It doesn't matter what her age or how long, but if a woman was already married before, then according to the hadith of the Prophet ﷺ, there is more than one hadith, she is entitled, if she wishes, to negotiate her marriage on her own without necessarily being represented by her guardian. In that case, for example, the father, if the father is living. And the text of hadith, for those who are Arab, الثيب أحق بنفسها من وليها. The Prophet ﷺ said that a woman who is married before, so that's the second marriage, is more entitled to, meaning between brackets, to negotiate or make the offer and or acceptance, of course, for marriage, more so than her guardian. But a virgin girl getting married, there are a common opinion, of course, based on some hadith as well, that she should give her permission if she accepts the person who's proposing to marry her, that she gives her acceptance to her father or guardian, for that matter. Of course, if the father is there, he would be the most eligible guardian. And the hadith also say, وَالْبِكْرُ تُسْتَأْذَنُ فِي نَفْسِهَا. They have to seek her permission. Practically, for example, when marriage is officiated in this masjid and other masajid in the area as well, that the person officiating the marriage send the father, who is the guardian, to seek permission of his virgin daughter to marry so-and-so. And the witness can go to the ladies section in case they are sitting in a different section. So there will be witnesses that she agreed to do that. So she has to give. However, there are some hadiths that's found in all 6 major books except Bukhari. So it still includes the Sahih Muslim and other Sunan, so-called. It says also, وَإِذْنُهَا صُمَاتُهَا. That means her permission, or enough to ascertain his permission, if she keeps silent. Doesn't mean she cannot say, yes, my dad, I authorize you to marry me. Yes, I accept him. But in some cultures, they might be too shy to do that. So if she blushes, for example, and keep quiet, then it is a sign that she does not object. If she objects, she has to speak up. All right. That is the common view about a virgin. However, one of the greatest imams, at least in the Sunni jurisprudence, Imam Abu Hanifa, great imam of a madhab that is followed by millions and millions of Muslims, especially in Turkey, in India, Pakistan, Bangladesh, and many other countries. Both he and his illustrious student by the name of Abu Yusuf are of the opinion that a mature woman who's discerning has the right to negotiate her own marriage, meaning without the intermediary of the guardian, and they say whether she is married before or if she's virgin even. It doesn't say she cannot do it, but they say she's entitled to that. But then people sometimes who objected to that, they say that there is a hadith also, more than one hadith, that on the surface, if you look at it, does not permit that. When the Prophet ﷺ says, for example, لا نكاح إلا بولي لا نكاح إلا بولي وشاهدي عدل, that the marriage is not valid without wali or guardian. But there was a response to that as well. They say the hadith, in fact, may be understood to relate to the case where the capability of the girl needs some support of someone with experience. Like, for example, if it's a little too young, if she's too little, or too young, I should say, even though she's in marriageable age, or again, in some rare cases, not in the full control of her mental capacities. So in that case, perhaps the guardian, who is normally the father, would act on her behalf, but still, in any case, she has to give her permission for in some way or the other. So that's how they combine between the various hadith. In fact, one of the rules of interpretation of the Quran, and also in usul al-fiqh, that's in the legal theory or methodology of Islam, they say takhsis al-am. In other words, there could be some hadith that applies to most cases, but again, it might be specified, or exception can be made in some instances. However, I do not wish to confuse anyone by adding some detail, because it is relevant, especially for Muslim living in non-Muslim societies, especially in the West. So I'm going to share with you also a fatwa, not the full fatwa, just to give you the part that's relevant here, a fatwa that was issued by the European Council of Fatwa, or Ifta and Research. And as I mentioned in some occasion before, it is a majlis that has lots of senior ulama, and it gives a great deal of attention to the minority issues, the issues faced by Muslim minorities in the West in particular. In Europe, but of course, a lot of issues and reasons or rationale for its fatwa applies to what we call Western societies. That includes Canada, United States, and even faraway countries that are basically similar, like New Zealand and Australia. In some degree, even South Africa might have something to share as well. basically they discussed that issue, the scholars discussed it, and they, of course, acknowledge that there is difference of opinion whether the virgin even, they all agree, of course, that a woman who was married before is free to negotiate without going through the wali or guardian. But having mentioned the difference of opinion, said it is a legitimate difference. However, they say the preference really is to have a guardian, especially for the virgin. The reason of their rationale, basically, is that in many societies, open societies you might call, liberal, whatever, in the Western world, it may open the door if the guardian does not have any involvement, even by advice and help or suggestion. It could lead to abuse, of that acceptable methodology, even of negotiating her marriage by herself. But of course, from my reading of the fatwa, it does not say it is haram. They say it is needed in cases like that. However, they acknowledge as well that there is a major problem in many societies, and I've seen examples of that myself, even in, let's say, in Canada. I've heard of similar cases in the United States as well. That is, if the guardian of the girl, virgin girl, refuses to approve the choice of his daughter for no good reason. Okay, we said that she's the final authority to say I accept or not, so there's no argument about that. But sometimes, instead of giving his blessing or acceptance or anything of that nature, he insists that she do not marry that person. No, you can't marry him, without good reason. A person could be of good character, could be a person who's capable of carrying the responsibility of family. So there's no issue. But no. No could be totally arbitrary, but in some cases also, it could be, no, don't marry him because I want you to marry one of my relatives or someone from our national home, or this or that, which are not valid criteria to reject. I say it's not valid not on the basis of opinion. It is based on the hadith of the Prophet sallallahu alaihi wasallam. إذا جاءكم من ترضون دينه وخلقه فزوجوه إلا تفعلوا تكن فتنة في الأرض وفساد كبير. يعني أو كما قال, the Prophet ﷺ said that if someone comes to you, of course the context here, seeking the hand of your daughter or your brother, your sister, in case the father is not living and the brother is next as a guardian. If somebody comes to you that you are satisfied with his religiosity and moral character, khuluqa, his character, then give your daughters in marriage to him. In other words, if there is compatibility and suitability. He says, if you don't do that, there will be fitna, that means commotion and temptation and evil on earth. Some scholars explain that means a girl who accepted a person who is religious and of good character, and she likes him, he likes her, and then somebody comes and say, no, you cannot marry him. That this is called in the Quranic language adl. فَلَا تَعْضُلُوهُنَّ. It appears in the Quran. Adl means using unreasonable or abusing a possible role that he may play as a guardian to prevent something good from happening. And again, in a case like that, it could be, as the Prophet ﷺ say, fitna, because now the girl might resent this abuse on the part of her guardian. She may refuse to get married at all, or she might just give no regard to her guardian. And marriage should be marriage not only between the two parties, but keeping the peace and harmony also with one's family on each side and between the two families for that matter. I know personally of at least one case that there was a young lady, very religious, mashallah, very articulate. She was really good in da'wah activities. And several individuals came to her father, and she was virgin. So, I mean, maybe she was not aware that in case of a problem of abuse on the part of wali, she can marry without wali if she's, in the age of majority and she knows what she's doing. She was a mature person, professional, in fact. So her father refuses. Another person, good character, good, refuses. At the heart of that refusal is the influence of some Muslim cultures which are un-Islamic culture. How's that? Not all cultural practices of Muslims is Islamic. If you say Islamic, it means it at least abides by the rules and teaching of the Quran and Sunnah. But unfortunately, among many Muslims from various ethnic backgrounds, I've seen that in the Middle East, for example, without specifying countries, there may be more than one. But also I've seen it in the subcontinent, and there have been cases also that came to my attention, that a person insists that the one who marry his daughter is either engineer or doctor or businessman. You could get a person with greater wealth or greater knowledge, but if he doesn't fall in these three categories, refuse it. No. If you can refuse, for example, if he's penniless and he cannot, look after his wife, because in Sharia, the husband is responsible for the household. But there are others who would say, no, I am from X country, I am from Egypt. You're only going to get married to someone from Egypt. Who said that? Who said that when Islam actually superseded all this false dichotomy among people by national background, by ethnic group, by color of skin, and all of these? Islam brought all together in one brotherhood. So this, while being a Muslim cultural practice, it is not Islamic. And as a result, in some cases, year after year after year goes on before that person, in the mind of the guardian, to give his consent or his blessing. There are cases where the girl or daughter might rebel and even marry non-Muslims even. There have been cases like that, which is the worst case, definitely, in that respect. I'm sorry to be, I should speak strongly about that, because we don't want those tragedies. And we want to educate Muslims also. And this has been part of the fatwa of the European Council of Fatwa and Research, or Ifta and Research, that adl, that is, if the family or the father, for that matter, unreasonably refuses to marry his daughter or to act as her agent, for example, in the nuptial agreement, because of no good reason, that she can actually negotiate her contract. I know it might be touchy, and some daughters might be reluctant to do this because they don't want to anger their. But if it comes to an important issue like marriage, maybe somebody should counsel the parents to follow Islamic culture rather than Muslim culture and open their hearts to a suitable person. That's called adl, and it is mentioned to that in the Quran. For example, in the case of a woman who was divorced, as I mentioned in the previous session, I believe, if a woman is divorced for the first time, even if the husband utters the word divorce, it does not mean that it becomes effective immediately, because there is a waiting period / maybe cool off period of 3 feminine cycles. During that period, the husband has the right to revoke his divorce, and can he invite her back so they can live together, no additional wedding or contract before the end of this roughly 3 months. But it's still counted as one divorce. So if a woman, for example, waited for that period and there was no agreement with the husband, there was no resolution of their problem, talaq or divorce become effective. And she is capable to marry whoever she wishes. So the Quran addresses the case where the woman is still within this waiting period, in which case, like I mentioned, maybe she wants to go back to her husband, or her husband and she agree to get back together, but before the end of the period. And if the wali refuses, that is forbidden in the Quran. فلا تعضلوهن أن ينكحن أزواجهن إذا تراضوا بينهم بالمعروف. That's where the form from the same root, من عضل. لا تعضلوهن. Don't prevent them, don't force them or pressure them or intimidate them to go back to their husband. It's not a matter of pride. How come, we gave heart to you in marriage and now you have a dispute and so on? No, that's their right to go back. These are some of the issues again of contradiction between Muslim cultures and truly Islamic culture. The European Council also suggests that if there is a case of the guardian who is abusing his place as a guardian, either that the guardianship moves to the next in line. For example, if the father is taking a very hard line and refusing for no good reason, wilaya or guardianship could move, for example, to her brother or to a judge. Of course, in Muslim countries, you can have Sharia judge. The system is there. But they say for Muslims living in Europe, and hence also similar setting like Europe, like North America, they can also ask to act as a guardian in place of the closer guardian, for example, the father. Those in charge of Islamic centers and masajid, for example, a learned imam in a masjid who's familiar with Sharia. Alhamdulillah, many imams now are qualified to do that. So they could ask the imam actually to act as a guardian in marriage. Okay, I hope we covered this issue reasonably comprehensively, because it's a recurring thing, and we get all imams around here keep getting questions like that. But then, before we finish the technical or requirement for marital contract, a question arises. Is it possible to add in the marital contract, in the West here they call it in legal term, prenuptial agreement at the time of marriage or before that? Is it possible to add additional conditions aside from those required in Sharia? You see, those required in Sharia that we discussed and detailed are necessary conditions, but it's not sufficient because some parties, husband and wife, for example, may wish to add conditions. The scholars divide these conditions into three categories. One is obvious. That is conditions that the other party must fulfill. For example, if a wife say to her husband, write in the contract, even though it need not be, but write in the contract that you will treat me kindly and don't abuse me, for example. This is something that he is required really to do as a Muslim, as the Quran says, وَعَاشِرُوهُنَّ بِالْمَعْرُوفِ, dwell with them, meaning with your wives, in what is decent, kind. And the hadith of the Prophet ﷺ also praises husbands who are good and kind to their wives. So that is part of what is Islamically required anyway. But if she wanted just to make sure and want to keep it in the contract, that's fine. So that becomes mandatory to observe. It's binding. Secondly, the husband also could say, I do not wish for anyone, for example, or a particular person to enter into my house without my permission, for example. That is also, as we'll detail later on, inshallah, the mutuality of rights and duties of husband and wife towards each other. Then it is wajib, because that's, again, we find reference to that in the hadith of the Prophet ﷺ. So that's one. Sometimes I feel it's not really that necessary, but some people, if they wish to add it and there's mutual agreement, that's fine. There are conditions, on the opposite extreme, that somebody wants to include in his contract or did include in case it's kept her attention. Something that is against the purpose of marriage in itself. For example, if he added that I have every right not to live with you as husband and wife. I'm not going to get into that activity, for example. That is invalid, and she will not be required in case even something like that happen for whatever reason. It is invalid because the purpose of marriage, as we've seen in the Quran and Hadith, is to live with one another, to satisfy one another, the second, and comfort, and also with the hope of having children. So if that is included in the contract, then the other party is not required to observe it. Okay? But a question arises here. Is the whole contract now void? No. The marital contract itself stands, but that condition that is against what Islam teaches is invalid. That agreement only, that part. And finally, there are also conditions that one side or the other may wish to include in the prenuptial agreement, that is in the marital contract, which are not of the first two categories, but are optional conditions, and the issue really is contingent on the mutual acceptance of both of them, of those conditions. For example, if a wife, for example, or wife-to-be at the time of marriage, seek a condition from her husband-to-be, until they sign, that he will not interfere in her completing her degree. For example, she might be studying medicine or something, and she's got 1 or 2 years, or any other subject for that matter. Say that you don't prevent me from completing my degree whether it's bachelor's, master's, or PhD, something in process, then there's nothing wrong for her to demand that, and that would be a condition that is binding on the husband. Another example, I am a professional person. For example, a wife might say, I studied 7 years before I got my medical degree, and yes, I'm committed to my children, committed to you, and also on everything, but don't prevent me totally from practicing my profession. It is up to them to agree to that. For example, he might accept if she demands to practice her medicine and make other arrangements. It may not be the most desirable situation because sometimes it could be at the expense of children. But if both agree and make arrangement that is satisfactory to both of them, you cannot say that this condition is haram. You might say it's undesirable. Some might come up with more creative solutions that she may simply say, I just like to keep in touch with my profession. So by the time we get our first child, Allah knows it might be a year 2 or 3. So I would like to continue practicing medicine and gain some experience. But I promise you, once we get the first child, we have to review that. I might have to work part-time, for example, or whatever arrangement. Or in one case I know of, it's that I agree with you. I'm also devoted to my children, and if I get a child, I might get out of the profession until my children grow up. Then I can, you see, whatever they agree. We're not talking in vacuum. There are many cases I've seen of that nature. So these are all examples, but again, like I said earlier, in these optional things, it has to be freely accepted by both. And some jurists said that in the prenuptial agreement, the penalty for violating the contract can be mentioned. For example, if you do that, I have every right to demand divorce with full compensation. You know, also penalties can be agreed to by both parties. Then remains another condition that is a bit controversial, and we can only appreciate it and understand it when we devote more time than the time that is remaining for this halaqah, which is 6 minutes. The question of known as polygamy. I'll just mention one thing only about it, that it is legitimate for the wife to include in her prenuptial contract that her husband shall practice strict monogamy and never marry another woman. Is that condition acceptable in Sharia? Does that condition imply that she's making polygamy haram? Because they say a statement basically about contracts. Muslims are supposed to observe whatever condition they mutually agree to, except a condition that makes something which is haram halal. Okay? Something forbidden, and that condition requires you to do, not to do it at all. Or making halal, haram halal, something that's forbidden, and the condition requires you to do something haram, like, drink alcohol or whatever. This is an interesting question, but I'd like to use the 5 minutes remaining, inshallah, to apply this whole discussion about the marital contract to people here in Nova Scotia, and I'm sure people in other provinces in Canada, possibly even in the United States and other jurisdictions, with variations, because as you know, the marriage acts are the provincial jurisdiction in nature. So I'm only speaking about Nova Scotia. And more recently also there have been an amendment to the Marriage Act. It's called actually now the Marriage Act. I'd like just to summarize a few issues that many people keep asking about. What happens if you want to get married? Answer: it is illegal in Nova Scotia for anyone, any certified marriage officer like imams who have the certificate to officiate marriage and sign it. It is illegal to marry any couple without having the official paper from Access Nova Scotia. It's called, you apply for a marriage license. That's one. Secondly, some people go to an imam and say, all right, I don't want to get into all these papers and official marriage. Why don't you marry us according to Sharia? Because in Sharia, of course, you have offer, you can fulfill all the requirement. It is illegal now and regarded as offense for any person to marry people without papers. In other words, because subhanAllah, we should be thankful to Allah subhanahu wa ta'ala. With certification of, we have a couple of people here in the area certified by the province of Nova Scotia to officiate marriage. And their signature would be like the signature with the same authority like going to the justice of peace or court to marry in a civil marriage. It is accepted. And they're not totally different from Sharia because they require, again, offer and acceptance, and both sides have to sign. And also it requires 2 witnesses, subhanAllah, just like Islam requires 2 witnesses. And that's even in a secular law without knowing even what Islam teaches about. It's not that Islam is totally opposite nor identical, but the overall process is acceptable. So why should we, after Allah subhanahu wa ta'ala gave us this recognition as legitimate religious group like other religious groups, whether Jews, Christians, and others, and then we say, no, marry me only Islamically? No. A person really should refuse to do that. It's illegal. It is also illegal. Somebody might say, all right, I'm not going to those imams who go by the letter of the law. I go to someone who's not an imam, who doesn't have the certificate. It is illegal and offense for a person who doesn't have a certificate from the province to officiate marriage. One final advice I think that we need to remind of is that to facilitate and speed the process of officiating marriage, it is highly desirable that you read carefully the papers that you get from Access Nova Scotia. In the past, alhamdulillah, you're luckier now. In the past, the regulation said that in order to apply for marriage license, you have to wait on the average, 5 working days before they issue the papers to you. But at that time, one side or the other, meaning the husband-to-be or wife-to-be, can apply on behalf of both of them and give them all the details about the age and name and whatever they ask in the application for marriage. Now the new act actually allows for issuance of the marriage license in the same day, even if there is time before they close, in the same day. But they require that both parties to the intended wedding or marriage go together to Access Nova Scotia. Now I think they changed the address now, you can check it in the internet. Access Nova Scotia, so that's the same place where you apply for driver license or renewal of your car registration. Now, they give you a number of papers and an envelope, self-stamped envelope. You should take all of these papers to your imam or the marriage officer that's going to do the marital ceremony. Secondly, don't waste the imam's time to fill the detailed information. There is a white sheet 8.5 by 11. It says marriage license, I think, on top, which has like 2 columns. They say spouse, on the other column, spouse. In the past, it used to be the husband and wife, but now they consider that perhaps discriminatory and not inclusive, so they say spouse and spouse. You understand the significance and pressure that brought up that change, but it doesn't bother us anyway, because you know, a spouse, to my knowledge, cannot be in plural. You don't say spices, except unless you talk about hot pepper or something. Spouse, spouse, okay. It doesn't bother, but it reflects the spirit of the time. Anyway, for each of these, not spices, spouses, anyway, they ask for the name, and be careful, of course, because you can't keep the last name in one. They have numbers also for those boxes. The last name, first and other names, the date of birth, age, and give information about the address, the present address of the spouse. It applies to both of them, so I don't have to repeat it, each side. The name of the father, the name of the mother, the place. They don't ask about their birthday, but the place where they were born and country. And the same apply to the other side, on the other column. They ask also about they call it your social status, not social in terms of whether you're married, marital status. And you have to write, choose from the choices given and write it, whether divorced, never married before, and so on, widow. So you have to give all this information truthfully and fully, but don't sign, because at the end of that column, just before you get to the witnesses boxes, it says the party signature. So don't sign your name, either spouses, because this has to be done in the presence of the marriage officer or imam, and you have to provide, of course, the imam with both your picture identification. There is another box after the box that's designated or left for the signatures, the 2 witnesses. It is better actually if you know your witnesses, the 2 witnesses that you're going to bring to the marriage. If you write their names, leave a space. There is a box, but write it in the lower line of the space, their names and addresses. There's one on the right side, one on the left side, but no signature again, because witnesses as well has to sign in front of the imam or marriage officer. These are essential information that you should get it ready. I remember one time I was preparing for halaqah, and there were some people who said, please, 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 just come at 6 o'clock. It is very short one, and you can finish. It's near the masjid, and you can come back for your halaqah. And I asked them, did you fill the papers? He said, oh, everything is ready, everything is ready. And what they meant by ready was the copy of the application they made to access Nova Scotia, but not the real papers that has to be signed. As a result, I had to sit down and ask them, and they have to go and ask about where your father was born and which country. So, unfortunately, by the time that was finished, subhanallah, I missed the halaqah. So that's why I will never accept anymore something that is near the halaqah. The marriage is a happy occasion. It's a moral duty. It's not a job that you get paid for. It's a moral duty. And I love to do it. My fellow imams love to do it to help the community. It's a matter of happiness when 2 Muslims can protect one another and get married. But please, keep away from the time of the halaqah. But in any case, whenever you get the marriage license, it is always desirable to call whoever imam that you wish for him to officiate your marriage to agree. Actually, they require advance acceptance that the imam, yes, is available. Some may be traveling, so you might be looking for someone else. So these are mechanical things, but since we're talking about the contract, and these are very common questions, and instead of repeating it, I thought I should include it. And Allah willing, I might, if I have enough time in a terribly busy schedule, to maybe make a guideline both in Arabic and English, inshallah, so that it would be available, or maybe if there is a possibility of putting it on the Ummah Masjid site or other sites of other masajid, so that at least people know exactly and save their time and time of others and be prepared for a smooth and hopefully happy and successful marriage, inshallah. We'll begin next time with the touchy topic of polygamy. Assalamu alaikum wa rahmatullahi wa barakatuh.